helping support. And tonight I got to see one of these happen a few years ago, and there is just so much information and it can be very confusing and complicated. And so it's just great to be able to have lawyers that come in and explain to families, allow you to ask questions. So I want to thank Matthew Gobatto and Chase Phillips from Cattell. And they are going to be basically presenting tonight, and you'll have time to ask questions at the end for attorneys. So thank you for being here.
Thank you very much.
Yes.
Yeah.
And remember, we are recording, so privacy, everything, don't overshare too much information. Yeah.
Good evening, everybody. I'm Matthew Gobatto. I'm partner here with Cattell, Gobatto, and Kyle. Gianna said this is Chase Phillips, associate in our office. Brief disclosure, we're here just to kind of give you guys some general information. We are not anyone's lawyer at this point. If there's certain things that are particular to your guys' situation and you need legal counsel, that advise you to reach out to us or anybody to get assistance on it. So today we're going to talk a little bit about guardianships. I'm going to present on special needs legal counsel. In terms of questions, easy going. So if someone has questions and we go through, feel free to.
Okay, so like I said, we're going to start on guardianships. So a guardianship is a court proceeding. The way that I like to describe it to people is often like a parent's relationship to this individual is an adult. And by reason of medical diagnosis, they're unable to make and communicate decisions on themselves. There are.
You want this?
Yes.
Yeah, sure.
Essentially, because you become an adult at 18, you're allowed to make your own decisions, right? That's something that you and I can appreciate every day. And for an individual who cannot necessarily make those decisions for themselves or be able to really appreciate the decisions that they're making, it's necessary for someone to come in and make those decisions. However, keep in mind that there are certain rights, just like you and I benefit from, that can be taken away, like an individual's right to vote, an individual's right to drive. And so the court takes that very, very seriously. Conservatorship. I like to make the distinguishment between a guardianship and conservatorship by first describing what a conservatorship is, and then everything else outside of that is the guardianship. So conservatorship is the management of a protected person's financial affairs. And so anything that really involves money is going to fall into the conservatorship piece of it. Now, keep in mind, if an individual is making less than $10,000, a conservatorship wouldn't be necessary. Or if they're only receiving Social Security income, which would mean really only a guardianship would be needed. We'll start with some definitions. So an incapacitated person is any person who is impaired by reason of mental illness, mental deficiency, mental disorder, physical disability, or physical illness, or abuse of drugs, blah, 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 to the extent that they lack sufficient understanding to make and communicate reasonable decisions concerning their person. Yeah, got everything. Okay, sorry, we as lawyers have these big long definitions. Anyway, so whenever you have an individual who is, let's say, getting ready to turn 18 or 17 years and 6 months old, again, leave it to attorneys to be very particular, you're at that point allowed to petition court to become their guardian, just so that way there's no really lingering period for them to be able to risk time for someone not being able to make decisions on their behalf. So like I said, they're a big deal, right? Because you have this proceeding in which you're coming to the court and you're asking the court to declare a person mentally incapacitated and to potentially take away these civil liberties that we all benefit from. And so the court makes that decision very, very seriously, which means they want a lot of information before they make that decision. A guardian also owes certain duties, like I mentioned. It's like a parent-child relationship. Those duties include some kind of cost there. We'll put it in. The guardian, though, in addition to these duties, has certain requirements that they have to fulfill, like filing an annual report with the court that says how they're doing, if the guardianship is still needed, if they've been seen by a doctor, that kind of information. So that way the court can make sure that, again, this person is being looked after, but also that this level of protection is still necessary.
Well, and Chase will go into this too, but one of the things that courts look, they want all of this in. Why, as the petitioner, we believe this guardianship is necessary. They want to see that there's a medical report that supports the fact that this guardianship is necessary. So the court's going to look at all of these things to try to make that determination. And because, we are taking away this individuals and we are putting somebody in their shoes to make decisions, the court wants to be totally informed. So the process itself is cumbersome with all the things that put together. So I think in a couple slides, Jason's going to go through. There's a litany of stuff that gets addressed before we ever get to a hearing, right? To have that decision whether or not a guardianship is necessary.
Yes, but even though stepping into that person's shoes, it's important to distinguish that you are not necessarily liable for the actions of them as guardian. There are certain duties that you have, and there's certain powers that you have the ability to consent to someone's medical decisions, find their treatment position, consent to education, different programs like that. You can even consent to marriage and divorce. I think that's pretty amazing. Anyway, continuing on. As Matt mentioned, there's a lot of paperwork that goes into this because, like I said, the court takes this very, very seriously. And I don't have this slide necessarily to make someone feel as if they can't take this on their own. They can. It's just a lot of work. They want to make sure you're checking out every single box before you even get to that hearing. Because in the event something falls through the cracks or something's missed, the court will literally put a pause on the hearing and continue it totally late until we really close to that document. So phase one is sort of the paperwork phase where you're filing things like a petition, a probate information sheet, an affidavit that speaks to have you ever committed a crime.
There's stuff on there. The court really wants us to do the student approach to take on it. They want to have, they have a list of 17 questions that relate to kind of during the ability to. And the petition itself kind of outlines why you think this is necessary. What's going on in this individual's life that has necessitated this petition? And why are you the appropriate party to serve it?
Yeah, and then once you complete all of that paperwork, that's when phase 3 kicks into place. That's when you get assigned a hearing date from the court. The court will also appoint a court-appointed attorney, and that's that one for moment, a court investigator, and also you'll have to provide a health professional. So that's that as well. Phase 3 is when you give notice to everybody of the proceedings. All interested persons need to be aware. It sounds silly that you have to make as many people aware as you do, but if you think about it, let's say if mom and dad are divorced and mom doesn't notice dad that mom's getting guardianship, or that can be a little offensive to dad. You know what I mean? Not a good idea. Then we move on to phase 4, which is the actual hearing portion of it, which you submit the orders and your letters. You give your letters almost as your sheriff's badge in order to act on this person's behalf. So if you're going to the school and you're wanting to make decisions on behalf of your protected person, you're going to need to provide those letters to the school. Like I said, don't panic. It's a lot, but you're absolutely capable of doing it. Okay, so remember those definitions that I was talking about earlier, the court investigator, court appointed counsel? Sounds exactly like it is. The court investigator is the person who the court appoints, and I like to think of it almost like as a third arm of the court. They're the neutral that comes in, the court literally appoints to go in and investigate what's going on in this individual's life outside of the case, right? Because the most biased person in the room is going to be you. You're the one asking for the GC. The court investigator is sort of there to look more into details to what's going on. They're going to interview the protected person. They're going to interview you, loved ones, maybe a teacher. So that way the court can have a perspective as to if this guardianship is necessary. And if so, who should serve as guardian?
And it's this investigator that you can't vote on. Maybe you actually say, I want to review And the family members, people who put their information to provide input. And then they author a report.
Sorry, I did.
They author a report that basically outlines who they discuss, with people they interview, kind of their conversation with the goals, and then it gives a recommendation to the court as to what they think is. Do they believe that the petitioner is the appropriate party to serve in this role? Do they think the guardianship is necessary? And the court puts weight on that report from the investigator. Okay. Yeah, go ahead. So what's the that's just the title that they're given. There's someone who's employed by the court to go out and to do this process and kind of investigate the situation as a whole. This is appropriate or correct, yeah, and they're going out there. I mean, the goal of the investigator is really just to determine the people that I've discussed this with, they think this is appropriate. The person that's applying, is there anything that I've come across that makes me concerned that they would be proper fit for this?
Okay, the next court appointed counsel, like I said, sounds exactly like it is. Now I want to make an important distinguishment. Court appointed attorney is someone who represents the express wishes of the protected person. So if this protected person goes to their counsel and says, counsel, I really don't feel like I need a guardian, I really just have to go to Mars, then that court appointed counsel has to go to the court and say, Your Honor, my client doesn't need a guardianship, they're really just interested in interstellar travel. Again, it sounds a little crazy, but it's so nice to know that there's someone there who's actually looking out and making sure that that person's voice is important. That's different between the guardian ad litem, which is another power that the court which represents the protected person's best interests rather than its best wishes. Like I said, they're appointed by the court. They conduct an interview with the protected person by themselves, so long as they're comfortable. But as the protected person wishes to have someone meet with them, that's something that they could absolutely do with all of that. During that interview, they'll sort of explain the process of what a guardianship conservatorship is, who's asking to be appointed, but also explain to them the rights that they have and the rights that could be used under guardianship if someone isn't. Health professionals report. This is a required document that the court wants to see authored by a doctor or a nurse or really any professional that explains the medical condition of the protected person and what necessitates a guardianship. So what ADLs are they able to do on their own? Where they should live, and what their least restricted environment is. The court absolutely takes this into heavy consideration because, like I said, this explains like the medical diagnosis part of that. I should explain that in the event you are asking for additional authority to consent to someone's inpatient mental health treatment, you're going to need this form to be completed by a psychologist or a psychiatrist. It can't just be any health professional. So there's a little bit more of a burden that we have to meet. But nonetheless, it's important to make sure that the court knows that this person actually really does need mental health treatment. Yeah.
You said it is an actual form that you would get from the court when, and then proceed with whoever else.
Yes. So if you're going to file a guardianship or guardianship with Maricopa County, if you Google health professionals report Maricopa County, there's a PDF that'll pull it up.
And it's a list of questions that courts put together that they want. And so they're all uniform and they just test things. Who's done the evaluation to fill out. Yes.
Around us, maybe that will be your office, my doctor, haven't yet run all of the other steps. Is there a no long sound?
I guess we're trying to be medical. But simply statement intellectually related. So versus they're not crazy, they're not independent, what an equity.
Meaning you're asking if
Whether or not that individual's in need of guardianship.
Yeah.
I mean, I think the determination is when you're doing the analysis. care for themselves and to be able to make informed decisions, are they susceptible to, being taken advantage of, those types of things. And so the range isn't this, like, hey, you have to be on this extreme, area in order to get this. It really is, it's kind of spectrum of, hey, we have different groups, and they just, the level of guardianship and the level of my involvement is going to be necessitated by what they can and can't.
It's pretty well something that people actually wouldn't necessarily depends on the medical issue, but there's something different. They have to report to you.
No, not necessarily. I mean, the health professional report will give the diagnosis and what, the developmentally disabled, whatever it may be, to the point that it is necessary that someone kind of step into their shoes. But the level of involvement of the guardian may shift, right? And, someone may be more independent than another person, and so the guardian is kind of there to nudge and offer assistance and kind of promote them doing whatever they can. And there's other types of the guardians having to do it all.
We had a question online. Can a physician assistant sign the health professional form?
Yes, so this is not.
Okay. Thank you.
There are, like, wording as a limited guardianship and that referred to private and building, but typically it's just a general guardianship. And it covers all, but then the guardian has all this discretion on what, this individual can do, and how much assistance they need, what resources are available that seek out on their own. So, the guardianship as a whole, the court is going to give you this general guardianship, and you're going to be charged with your ability to work with the individual and allow them to be as independent as possible. It's, vary between guardians. Yeah, I think the guardian gets to make that decision. Yeah, I don't think that the court is going to sit there and outline it in an order, but you as the guardian has firsthand knowledge of this individual, around this individual, can kind of assess that situation.
And just kind of sharing with that, just, I know every time we do this, we've already been through this. Like personally, we've taken our daughter's right to vote. So that was just kind of embedded in the paperwork and lots of discussions about it and everything too. Yeah, she got called for jury.
And I don't think that the part.
Yeah.
That has to be for.
On top of that, I mentioned there's this level of discretion. One of the duties that guardians have to the protected person is they have this fine balance of acting in that individual's best interest, but also listening to what their best wishes are. So in the event that they're able to make those decisions, that's absolutely something that we should consider in acting on those decisions. Oh, I should say too, health professionals will likely charge for these, so just keep that in mind. Generally, the health professionals reports and
Yeah, and so it depends. I mean, I think someone who's 17 and a half, who's had, this kind of life, they'll fill up. If it's, someone all of a sudden there's accidents, now we need to petition to become a guardian. They haven't seen a doctor in a long time, but their life events have changed. And yeah, trying to get somebody to do this, then they'll do. So, case by case basis.
so, okay, so then once we complete all of that hard lifting paperwork, get to the court hearing. And like I mentioned, whenever you get to that hearing, there's one step in the paperwork that's missed. Run the risk of the court resetting the hearing and delaying it. I had an experience where we had a 17-and-a-half-year-old who was trying to obtain guardianship over issues. We get to the hearing and there was something that the court missed. We've heard before, but it was just the fault of the court where we had to reset the hearing. And the court wanted to set it after the 18th year, which again, we run that risk of a period in which someone is able to make decisions themselves. And so we want to be mindful of these dates. So that way, like as soon as that 17.6 month happens, we want to be sure to get everything filed to get the ball rolling. So if anything happens, you have enough time, that you're not up against the clock. To give you an idea, right now the courts are 5 days out, unless there's an emergency. And again, we go to if needs to happen. But in the event that someone is going to become detrimental to their health, their safety, their welfare, and there's an emergency situation going on, that's when the court will have a different sort of circumstances, so that we can get it done earlier. Because the court does recognize that there are emergencies that happen. Don't anticipate someone. We don't anticipate someone forcing the other case for you. So I don't know what happens.
And not everything, I mean, the court clearly looks at, is this an emergency? So, oh no, I'm late to file, I'll certainly to tomorrow, it's not an emergency situation. You know, so there has to be some discretion, fairly aware to not be. Yeah.
So say in the case that you said that they wanted to move the cured and the child or person has now become patient, is there something that you can do in ensuring like a temporary guardian or something temporary?
You would have to file and requested a temporary. Typically, if you're filing and you have 17th, you would have requested a temporary, you would have done it. So,
Right, so, but in the case that you were saying where they moved the hearing, could you file it that day for a temporary for the, say it's 5 days until your next hearing? And if the child just in between for those 5
yeah,
days?
procedurally probably not. Okay, you still have all these notice requirements, you don't really request it. Just a temporization, and the only way you would be able to certain that some of those equipment would be an emergency and the court's not going to find it being over the that would be some other circumstances surrounding that would be tolerated. You
At that point, would you, I guess, file to be filed because there's like something like that?
no, the whole reason you're filing is because the individual funds get off of the power to the
Okay.
they can't achieve one. So
Okay. You're just out of luck. It's just something that's like in those days.
Yeah.
and the court usually understands that this is being reset, so they're not sending it out another 45 days.
Okay.
To, you know, depending on the technicality of what's going on, barring some objection to another party, or you know, tries their best to get back in at least to address that. And I've had it where, you know, there's been an issue and we've taken testimony, we've done all the housekeeping stuff that we would do at the permanent hearing. I just requested the court site for an non-appearance to let us get into compliance with whatever they're requesting. And all that is we file the paperwork before the next one dates. There's some flexibility with it. Yes.
And in this instance with this, individual who was getting hearing 3 days before we did this, so the court originally wanted to set it after. So I just honor and said that it would want to make sure that someone has the ability to make these decisions for them. The court was like, okay, that's, if that's something that happens, you be sure that it's not to the court. And that they will be able to invest in.
And there's been times, I mean, the court investigated, it's not a ton. So there's a lot of cases that get filed in Maricopa County. And I do think they try their hardest to get it not always punctual with the reports. And I don't have any ability to come. So there's been times, and it hasn't happened recently, that court investigated reports happen. Or that we made the request and the court somewhere along the way, the litigation was stopped and the court investigated and got the assignment. So, you know, those types of things are outside of our control, and so the court understands them. So usually in those situations, in order to go out, do the investigation, as long as it comes back favorable, you guys don't have to put that court out.
And that's exactly that. Okay. All right. So once you get to the utilizes benefits, a Teams server called Court Connect. Again, it's not very clear. And this allows you to join the proceedings from home, which is really nice. If you're not technologically inclined, there is a phone number that you're able to call and dial in. I always though advise that appearing on camera is so beneficial because it allows the court to see your demeanor as you testify, as to why this guardianship is necessary and why you're willing and able to serve on behalf of your life.
Yeah, the courts love, they encourage you to appeal. And so, the benefit of this is I don't have to drive, the courthouse. You don't have to go to the courthouse. Even if your child can be on the same camera, it saves a whole bunch of time. So, we always send it out to everybody in advance. We'll send you the link. I always have like a test run. So all my clients say, get on there. You're not going to, the court's not going to let you in. But just try it. Give it a run through. Make sure you get on. If there's any issues, let us know in advance. We kind of want. So.
I just wanted to check my understanding. So are all hearings for guardianship now being done virtually?
They are, you can go to the courthouse, but I think judicial officers, myself, all prefer.
Sure. Okay.
But the court's not going to tell you that.
Okay. But they're not going to require you to be in person.
No. Well,
My experience is a little different. So I specialize in contested guardianships and conservatorships, which is different than this process. So in the event you have two individuals who are fighting over who should serve as guardian, or let's say you have a loved one who is objecting to being a protected person in the case, that's when the fight happens, and that's what happens. And in circumstances where you have a fight, sometimes the court will require you to appear in person for a trial, for an evidentiary hearing, for a settlement conference, different things like that. So for proceedings like the straightforward guardianship where everyone's happy, everyone's getting along, and we just want to make sure that this loved one is taken care of, it is likely that you will not have to appear in person.
outside of the trial, some evidentiary with plots. So, put that there.
Yeah. So, and a lot of people always ask, does my loved one who I'm trying to do guardianship over, do they have to attend? This is a great question. They will meet with their attorney, their political counsel, and we will discuss whether or not they want to attend. If they want to attend, great. If they don't want to, they don't. The court, of course, is not going to, like I said, require it. So it should just pretty much. Oh wait, but I should say if they can, and they want to, they have to.
And one more thing on that, I think want to go to the next slide, but procedurally, we have to serve the individual that would participate on the vote. So it sounds silly that, they're leaving the same houses here or whatever, but statutorily, we actually have some process so that they have to serve them. It has to be done 14 days before the vote. So that way, this individual at least have notice of what's going on. They can make a decision.
And of course, it adds what Matt said. Of course, we're talking about these proceedings in the context of what wants to go by the case, right? Of course, there are guardianships that do become necessary for, let's say, a grandparent who develops Alzheimer's dementia. And so, while most of this would apply to them, we've got different circumstances in which maybe that would be the best thing for them mentally. Or maybe they're not able to vocalize what their position is. So their attorney will help them. Okay, yeah. So as Matt mentioned, and this gentleman asked about earlier, there are per se to a guardianship. So for example, retaining your right to drive and your right to drive. Those are sort of the tiers that the court generally looks at. And Matt mentioned if those rights are to be affected by the appointment of a guardian, you are going to need that professional support to support it. And if you look at it online, there's even a little box of it. Actually, before I move on from this slide, if you do want your loved one to retain their right to drive, something from, like, let's say if they're in driver's ed, that would be something that would be beneficial to them. Nominating successor guardian. A lot of people ask that if something happens and I'm not here to act on my loved one's behalf, what do I do? Unfortunately, there isn't necessarily a mechanism that allows a successor guardian to just have them appointed upon the vacancy. But there are steps that you can take to speak with your loved ones and have open conversations about, something would have happened to me. I would really love for you to be a child's guardian. I would really love for you to help, take care of something, or maybe even be a co-guardian. That's something that you can help. So often parents, and even one of the siblings will all become the guardians. There's not a limit to it. I will say though, it does invite a fight. So be mindful of that. Of course, I do observe on for me, but yes, sir. Yes.
Yeah, so there can be differences. And so let's say, for example, one, parents, a 18-year-old, and they both want to go. So they can be both. And I do this all the time where we file it with independent authority. So, parent one, is traveling and something happens, parent two can still, and that way, if something happened to parent one, parent two is still available. Nothing changes in assistance for the individual. With respect to backup stuff, I don't get to say who's the backup. I can put in my will, I want Chase to be a guardian of my kid if something happens to me. But it still necessitates just going to court to say, hey, Matt left this will. He wanted me to be the guardian. I should have priority to do this. Nobody's here to it yet, but it's not an automatic. And so when, we have parents, we do it as co-guardian all the time. When I see the need for a co-guardian, a lot of times parents that are getting up there in years and recognize the need for someone to eventually take over for their child as the guardian, they usually we file a notification to say we'd like to have a one. Maybe that's a sibling, individual, or a relative, because I know I'm not going to be forever. I don't want them to lapse in transition or someone's there. So you can always petition to have a guardian. So doesn't actually be that. Well,
I can be this issue.
Yeah, you have a question.
Yes, these guardianships, these are, 18 years of age.
Yeah, they probably petition 17 and a half, and they get 17 and a half.
But my case is, and then I was 14. At 75 months.
Okay.
So actually, this is not the one place in ours.
So you filing a different board, so there's you still can be the guardians. Okay. Yeah, I mean, if for minors, people under the age of 18 can still, if something happened to parents or whatever, there was a need for guardianship, you can still file.
Okay.
There isn't
So with that to the back up guardian, or in the event of my son will be taking the right? If you get some son,
what is are you the guardian now?
I'm going
You could petition to have him as a co-guardian with you. That would be all you could do at this time. And then if something did happen to you, it wouldn't keep it lapse it. And do that. If you didn't do that, if something happened, you'd still have to petition to become the guardian.
That's a really excellent circumstance to point out. We have families of all different shapes and sizes. And while a co-guardianship might fit your situation, it's always mindful to be, or it's always good to be mindful of who you're selecting to be co-guardian. Is that something you could do? Absolutely. But just make sure everyone's getting along. And that you're able to, work with this individual as time goes on. Because if something happens later down the road, they're going to need my services, which I always tell them. So go on, and you don't have to take this. But if there is a fight and you run the risk of having to request the court to remove this person, because, like I said, there are a lot of duties that come with this, but you have to. Okay.
Oh,
sorry.
all right. Oh,
I have a question.
yeah, go ahead.
The guardianship in the co-guardian, is that nationwide? Or is that just?
I can tell you, I mean, different jurisdictions have different rules. So like some states, just use the term guardian, but that applies to both guardians. So still, you might feel that different terminology. So there are guardianships, in every state, but whether or not there's different rules that apply to it. So,
Okay, so it's a state by state thing. So my parents are guardians of my brother. But I live here. That's why I was wondering, is there?
yeah, there's grants. So let's say something happened to your parents and you need to become a guardian who's coming out there. There is a transfer back. Where you can say you've done a guardianship and you do it here. You have to give the guardianship plan for theirs. Okay, special needs trust. Special needs trust. So the purpose behind it is that we have an individual who's receiving benefits and we don't want to jeopardize their fund, whether it's money coming in from an inheritance, settlements. We need to be able to safeguard those funds and keep them separate from accountable reserves. And so special needs trust, they do not impact the $2,000 asset limit that a person can have SSI on tax. If they're properly drafted, they're not counted sources. And the fund really should be used to advance the individuals. So I put over here just an overview. The trustees, the individual who's going to manage the money that's in the trust. They're going to be in charge of figuring out how this money is to be spent, the individual that is to benefit from it, what are their needs, and how do we use this money appropriately without, jeopardizing the current benefit status. Beneficiary doesn't get access to this money. They don't get the cash. They don't get to say, I need this. They get to go to the trustee and say, these are certain things in my life, and I'd like them to be paid for the trustee. And then they'll say, let's take a look at this. We have the fund for it. Are we going to risk losing benefits? No. Okay. First party special needs trust. First party special needs trusts are trusts that are created when money has come to an individual that would be considered accountable. So, like I indicated before, mom and dad maybe left an account with the individual as the beneficiary on it, and that money, if it went to them, would jeopardize their health tax or SSI money. And so, how do we make sure that money is not counted? Well, we have to go and create this first party special needs. And the individual that's receiving the money must be under the age of 65. And typically it can be created by a parent, a guardian, or by court. The issue with this is first party special needs trust have a mandatory pay off provision. And so any money that we loans in the special needs trust that an individual passes away will go to the state. So we'd like to avoid first party as much as we can. Sometimes it's not possible, and we want to make sure the benefits are protected, so we do this. So I have on the slides this example. Will was enrolled in ED and all tax SSI payments. He has all tax benefits and a 35 her grandmother passing away in his estate worth $500,000. The result of Will getting that money would be a loss of the benefits. The $500,000 probably is not enough to sustain Will for the rest of the life, and so well, the petition to get this first party special needs trust created, you have the inheritance money placed in. And now we can use that $500,000 to enhance one's life without jeopardizing the benefit. There's a lot of requirements though that come with the first party, not just the creation it, but actually there's a budget that has to be submitted to Alltex on how you propose spending the money early. And not get cash distributions to the beneficiary. You have to account for how you use the money to all months. And so the trustee has a big job when they're in charge of the first party. Third party, this is what we try to get established. This is a trust that is created by an individual that says this money is going to be used for the benefit of Wilma, for example. And Wilma never ever had access to that. So the example that I think is easiest for people to relate to is We created an estate plan as parents. We want to make sure this money is used for our child's benefit without jeopardizing any of the assistance they receive. And so we created third-party special. As an example, my trust would say, hey, when I pass away, my money goes to this third-party trust. Now, it's never considered a counted resource. There's no payback for the state, and yet I still have a trustee that gets to manage this money for my child's benefit. I also tell my clients, if you have a grandparent or an aunt or an uncle that you think might leave money to your child, you need to have that conversation with them. Don't leave the money out. We created this third-party trust. If you're thinking of leaving it to Wilma, leave it to Wilma's third-party trust. And here's the information. Because if they don't, we then have this issue. So here we go. I think, I talked a little bit about Wilma's situation. Rather than the money going directly to Wilma, if Wilma's grandmother had created a third-party trust, that money would be in there. We'd have a trustee using it, and we wouldn't be reporting to all tax and doing the budget. We get a lot of flexibility with it. For one time saying this, the special needs trustee rules, and that's it. We don't have to account for that, so we don't have to continue to do stuff. The third party gets to use it without any sort of budget for all tax. And we don't pay back to the state. And so one of the benefits of having the third party trust is that I can say when the individual that was the beneficiary that got passes away, if there's money remaining, I can designate it. And so I get a lot of flexibility on putting this estate plan together. Third party, go ahead. Yeah, go ahead. So, yeah, the trustee gets to decide where they want to put the money. Some of that's based on how much money's there, what I think the needs of this beneficiary are. Like, do I have enough money where I can kind of invest and grow this and have enough liquid that I can, sustain for 2 years and then put some money aside? Just want to put it in a checking account, lots of money in the CD. So the trustee gets a lot of discretion in deciding one, the institution or institutions where they place the money, and three, how they finally want to hide it.
If the child has like a job, part-time job or anything, can they put their paycheck into that?
So, we wouldn't need to necessarily. They could use that money. So if they have the job and they're not over-resourced, the child could use that money for what they want. And this third-party trust would supplement everything that's not covered. So I don't know that we want to put the child into that because they're already reporting that one.
Yeah.
Right. They're already showing that they were getting this. And they have the ability to do that. So I wouldn't suggest, as long as they're not considered over-resourced, putting it there. Okay. Third-party trust can be established as part of a will. So the will that says my money goes to, and kind of outline the trust. They need a separate trust document, which I am a major proponent of. Typically, when I do these types of estate plans, I do a separate trust document. It's nice, it's clean, it's its own little entity, and you know exactly what it says without anything else. And then you can have a sub-trust of your trust that says these are kind of the terms of play.
You don't have a pet trust.
So reporting requirements for first party, rights and responsibilities of the trustee form, anticipated disbursement form, provide documentation to all that's annually. It's a lot of work. And so it's great because we still preserve benefits, but it's all text, no rhyme or reason. Come to you and say there's budget, and 1 month they say, yeah, that's approved, and the next month they had more questions. So when putting a trustee in place, that's another thing I don't think I touched on in any of these slides, is that when you're deciding to put these trusts together, you're deciding on who you want to manage this institution. And so you have to put someone in their trust and confidence. Are they capable of doing it? Do they have a financial background? Are they savvy enough to do it? We don't always have people in our lives with requirements, and so there are third parties that are out, fiduciaries and corporate trustees, and so I think it's a very important thing when deciding who the trustee is going to be a career. long term, we don't be responsible about that. Able and stable accounts. So able accounts, a little dated there. So in 2026, actually, this just changed. So anybody younger than 46 can establish an able account. And an able account is a way for us to put up to $20,000 a year into an account for us to use for that beneficiary. It is subject to Medicaid payback, but it doesn't have all the stringent requirements of accounting that the first party does. And so it can hold up to $100,000, can only be funded to $20,000 a year. If it goes above that $100,000, your SSI could be suspended, but usually we're using able accounts as we fund. This is a great way that you have discretionary stuff. So, let's say we had let's take one more, for example, we had that $5 million. Well, when I do my petition to say, let's put it to the first party, I asked them for 20,000 to be able to, because now submitted my budget to Altex and something came up and put it on there. I can use the able account. I don't have to go back to Altex and amend the budget or request authorization tables. I can use the able account. If the beneficiary is working, they can also contribute to the able account. So it's in addition to the 20, they can put in up to 15,000. So if they kind of want to use it as a savings account to have money in discretionary funds, it's a great way to do it.
So would you say that they're using multiple accounts, that would be first and or you would suggest using not just other.
Yeah, we have a first party special needs trust. We typically always have an able account. We actually always request that it gets set up, just because it gives us a lot of flexibility. And the same requirements as the first party, you still pay that. So, and the money in the account's not counted. It's not considered a counted resource. It's like it would be in a first party and third party. It's free to set up. It's all online. There's no brick and mortar. So, and then you can invest the money too. And so it can have income and it can grow. I have some of the reasons, so this might answer some of the questions earlier. Some of the reasons for establishing it is a small inheritance or there's a personal injury settlement that's 40,000 or less to put money into the able account. We don't have to go through the first party. You can have excess wages placed in there, and you can use it as a savings. You can roll a 529 plan into an able account, and in all my first party special needs trust, I always have language in there that says the trust between fund and able account and can be created. And so when we're doing our budgets to Altex, we always put in there 20,000. If you want that discretion, you want to have these funds available. There's no budget, no anticipated disbursements prior to approval on it. That's another benefit. You have a lot of flexibility. And so some of the expenses we can use education, housing, transportation, employment, certain things in the first party trust can't use for money. They use it for rent or mortgage payments or property taxes. Here we have no discussion. I touched on this before, but there are the limitations. It's now 20,000 a year in terms of contribution. Can't have more than 100,000. You can use it for a lot of different things that you can't use with the first party. And then the combination. You can use an able account with a first party. You can use an able account with a third party. They're all reported, but it's utilized. All right, and then I have a brief summary up here about kind of all the stuff we talked about. I think it's the last one slide, so I wanted to open it up for questions.
Can you move money from an able account into the third party trusts?
That's a good question. I think you could. I don't know if I think you could. You could move the money into
Just thinking that it's growing, not that much, but
yeah, I think the only problem is what's the original funding source from that, because in theory, there's this payback. I mean, you can't really have cash distribution to the individual, but it'd be a way to kind of keep money outside of that. So I don't know whether or not they qualify. I could look at it and see it. But my only concern would be, you know, it's discovered this and he's trying to.
Yeah.
Are you talking the able count or first party? Yeah, so there's, I think I had up there before, I mean, this is not an exhaustive list. This list is kind of common that you come across that you want to use the able count to pay for, but it doesn't mean that that's the adult.
So say you're in your brother wants a PS and 5, 6, whatever.
You can use it, you can purchase it.
Okay, good. And you would do that through the able account because the other ones are, you have to fill out a form and then you have to.
When you have the first party, you still have to submit this budget, right? And so there are certain things that you just may not have anticipated, it's something that came up. And so this is a great way for us to say, okay, we have something that's come up and we didn't budget for in our application for this year. We can go ahead and use the able account for it. Yeah, go ahead.
What would happen if you're in the sole safeguarding of the experience, part of the which they have before you know, there's no one to basically, you know, take over from you. You keep children in financial events or have these huge and they're not able to effectively be the guardian. Guardian that person, there's no one in place for the state to take over, but I'm thinking.
That's a great question. So, if you look at the statute, I believe it's 14 document 311 lays out a list of priorities as to who can serve as guardian. The priority list is, and they found. One of those individuals that we report for is what's called the public fiduciary. The public fiduciary service is supervised like Arizona, a license. But like most services, we are underfunded and underutilized. And so the level of involvement that the public fiduciary has is limited. Not being out of desire, but just out of resources to be able to care for your so that is a resource available. Should something.
Well, let's think if you're level with building an apartment company and they're responsible for making sure everything's paid and whatever, all of a sudden I'm not there. There's this state fiduciary and then take up all of the connecting around the basically they're putting like a group home, I think they're selling it.
Like who was paying, in your example, like assuming there was no fund, government didn't have any funding, you were funding it, right?
Or maybe let's say she gets fined for limited spending, so I should have been a partner on the education, all that stuff. And they come to the company. Something happens to me, what else is going to take over? What happens?
Yeah, I mean, if there was no other family member that could step up, no other person of interest that could be willing to put the sign of case indicated, it would be the public fiduciary. You're typically the last resort. So, you know, in your situation, if there was no other sibling but an aunt or an uncle that be willing to settle, they would have priority to go and settle, you know. So exhausting all family members, then
I've also seen others. So this might be to them.
When I've been doing the process and trying to circle around that child and then keep on going out as full time until they find somebody who works for that.
yeah, I mean, there's certain parameters. So there's the statute that kind of delineates who has priority. And part of that statute is if the individual in needing guardian can articulate or express who they want, then that's to be taken into consideration. So, you know, even if it wasn't a family member, but it was a very close friend, and someone who was in the same individual's life, that person can articulate, yeah, I'd like to be my guardian before here.
We do not have any more online.
Okay. Well, thank you for letting
Thank
us-
you so much. We
Yes.
appreciate it.
No,